The DA, Helen Suzman Foundation and AfriForum are appealing against the granting in September of medical parole for former President Jacob Zuma. Zuma had earlier been sentenced to 15 months imprisonment for contempt of court. For more on the legal implications, we're joined by legal expert Nthabiseng Dubazana. Thank you very much, ma'am, for your time. Now, the argument so far in court that we've heard has been about the former president's activities before and after his time in prison, right? The different applicants are saying that he was able to address the media prior to going to jail, and even after that he was seen at a casino, having meetings with political allies, etc. It seems like a legitimate argument to me, but what do you think?
Well, I unfortunately missed the applicant's address to the court. I caught it in the respondent's address. From what I gathered from the respondent's address is that, be that as it may, that he was able to address media or the public, or he was able to go to a casino. It is not medical proof before the court to go against the medical proof that was supplied at the hearing where he was granted the parole. So what, in essence, the defense, the respondents are saying in this situation is that failure of them to bring to court medical proof that sustains that he can be returned back into custody and serve the remainder of his 15-month sentence, then the court has no basis to discharge, or rather allow him to be sent back into prison. Further to that, I heard the judge asking that, okay, on top of the fact that they are dealing with the media reports that were out there on Twitter and everything, he asked, what about the commissioner who had then overruled and said that former President Zuma should now be released out on medical parole? That's another issue that they need to address, and another issue that he needs to decide on. And then the respondents were saying that, be that as it may, the fact that the commissioner has done that, he is given the right in terms of, actually I think it's section 35 or 73, I forgot, whereby he's given that right, whereby he can overrule the decision that was made. So basically, I think the bottom line here is where the judge is going to look at whether there is sufficient legal grounds, one, and also whether there is sufficient factual grounds that will allow him to say yes or no to whether or not Dr. Zuma should be returned back into custody.
Well, I was going to ask you actually about that, because as you say, the Parole Review Advisory Board did say that there were no grounds to grant the former president parole. So would you say, in your opinion, if you could just indulge us, did Arthur Fraser probably just use too much authority to make this decision? Would you say that he was overreaching?
Well, from what I could gather, he based his reasoning on the doctor's report, whereby it said that even though the words terminally ill were not used, but then I think it meant that he is severely ill. I think based on the doctor's report, that's what he based his overruling of the decision that was made by the parole board. I don't know if it was exactly overreaching at this stage. I'm not privy to exactly what the exact content was, but I think that based on that alone, he probably thought that he was acting within the bounds of his powers that were granted to him by the legislature. So as we are standing right here, it is now up to the court to decide whether or not indeed he was overreaching, or he has worked within the bounds of what he was allowed to do, and as a result, therefore, he can then make the decision, or confirm the decision that was made in September to release Dr. Zuma out on parole.
But nobody can deny that this period that South Africa has had, because this also goes back to the Constitutional Court, of course, which is the court that made this decision. It really does teach us a few lessons as South Africans, doesn't it, in terms of our law and our Constitution?
100%. I think it has been one of the most exciting times for me, at least, in terms of the law and in terms of how the law has changed as a result of this specific case, in terms of how we're going to deal with criminal cases, in terms of non-appearance at court. It has set a very interesting precedent, which might work to a disadvantage in some level, to be quite honest. But as we learn and grow, it's very interesting and how it's going to be applicable going forward.
So what then happens here after the decision? Let's say, for instance, the court decides that Arthur Fraser did not go, he was not overreaching, and that his decision was correct. Or rather, let's say the court decides that actually he was overreaching. Does that mean that the president goes back to jail to finish off that very same sentence and started off from where he left it off? What would that mean?
Not necessarily. Part of the arguments that have been set forth is that his actual parole, the half period for the parole has actually commenced. I heard the judge asking that, let's say that I confirm that Arthur Fraser did overreach, and then the Zuma has to go back to prison. Then what would be the next step? And then what was answered, like vaguely answered actually, was that then the court would have to decide what to do from then on. In my opinion, it would be that should it be said that Arthur Fraser did overreach, and then it is said that he must go finish off his sentence in custody, that's not the end of it. We still now have the right to take it, or the respondent will now have the right to take it to appeal to the SCA and see if the SCA will concur with the lower court. In this instance, it would be the High Court that he's currently appearing in now. And if they confirm it, then they can still take it to the Constitutional Court to see if they will agree with that situation. I don't know if that would be a good idea, considering that the Constitutional Court was the court that actually put him here in the first place. But those are the steps that would be followed. But, I don't know how it would work out, because they'll be overturning their own decision should it go back to the Constitutional Court, come to think of it. But that is if it is found that Arthur Fraser did overreach. But if it is found that he didn't, then he continues his sentence currently where he is. And let's say, for argument's sake, it does go all the way up to the Constitutional Court, and then for whatever reason they don't confirm their own order, which happened in the first place that got us here, and then they say he has the right to continue with medical parole, then that's the end of that. But if they reconfirm, if I can use that word, I don't know if it exists in English, the order that they made for the 15-month sentence, then he goes back and finishes off the remainder of his sentence.